Good morning. The 14B District Court is now in session. My name is MIWashington, and I'm the judge that will be presiding over this session. Please make sure you keep your voice, Please make sure that you keep your computers on mute and wait until the attorneys have placed their appearances on the record. So the prosecutor will place their appearance on first, and then the defense attorney. State of Michigan versus Daquan Delane, case number 23S00369.
Good morning. I appear Rachel McDuffie for the people.
Good morning.
Good morning, Your Honor. Jude Rich and Anna Semiday for the defendant, requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Sarah Salin.
Permission is granted.
Thank you, Your Honor.
Mr. Delane, please state your name.
Daquan Delane.
Thank you.
You're welcome.
All right, we're here for a pretrial and bond violation today.
That's right, Your Honor. The defense would like to ask that we move to final settlement conference, both for the underlying charge and for the alleged bond violations.
We're not moving to bond violation on a final settlement conference. We're going to address the bond violation.
You'd like to address the bond violations today? Your
We're
Honor?
going to end this off for three hearings.
Yes. Well, because we'd like to move the underlying charge to final settlement, we thought that it would be a good idea to also address the bond violations at the same time because the complaining witness is the same witness.
Ms. McDuffie?
So when it comes to bond violations, usually when we end up moving things or kind of kicking the can down the road, it's because there's a new charge that might constitute a bond violation and that hasn't been adjudicated as of yet in terms of there being a conviction that will violate bond. Other forms of bond violations that involves for testing violations, things like that, and especially in cases like this where there's contact violations, need to be addressed up front because it's not really going to become a moot issue by kicking that down. Mr. Delane has 2 police reports with violations of no contact orders on this case while the underlying case was pending. So that's why we need to address those now because that's not nothing.
All right, so are you prepared to move forward with the bond violation? I guess is what I'm asking.
I think we would need.
I'm not talking to you, Mr. Rich. I'm talking to
I
the
apologize, Your Honor.
prosecutor.
So, Your Honor, well, I mean, we have the reports and we have, I think, the media associated with those. I guess the question would just be how defense intends to address it, if he's going to admit to the violation or if he's asking for a hearing on it or what, because I don't know what they're planning to do.
I think we would need a moment to discuss with our client.
We've had those moments. We're past that point.
I'm sorry. The media, we don't have the media of the actual police calls. We only have paper reports. So Ms. McDuffie, I'm not sure which media you were referring to.
So, Mr. Rich, it's probably helpful to reach out to discuss these things so that we can kind of coordinate this. So the case that was dismissed at exam is one, and you all aren't on that case, so I guess the media wasn't sent to you for that. And the other one, I believe, is just a police report, if I'm not mistaken.
Okay, we asked 2 weeks ago for everything that was available for this, and we only got a police report.
Well, yes, the request is for please forward all violation complaints and reports. We have that. So here's where I'm at with this. If Mr. Delane is not prepared to admit to the violations of no contact today, then we need to schedule a hearing. I don't have officers present to hold a hearing today. We still have to address this today.
All right, so what I'm going to do is, are you available for April 8th for a hearing, counselors?
Let me check really fast, Your Honor. I apologize.
Your Honor, may I ask what time the hearing would be?
11 a.m. in person.
That works for defense.
Thank you. And then we'll give you your final settlement conference on April 25th, 2024 at 11 a.m. And jury selection will be May 3rd, 2024 at 8:30 a.m.
Thank you, Your Honor.
Ms. McDuffie, if there is any media which we haven't received, we're requesting that now. Would you be able to send that over to us, please?
I can have it sent to you.
Thank you.
Bond is continued for now. We'll see you here on April the 8th in person at 11 a.m.
Thank you, Your Honor.
Thank you.
Yeah, you too.
I will call the matters of Christopher Caldwell. Case numbers 24S00021, 23S00776, and those are the two.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Christopher Caldwell on 23S776.
Christopher Caldwell.
Thank you, Mr. Caldwell. There is see it here. So the PD I thought withdrew.
On the case where he's being sentenced, which is the R&O case, the PD is still on that. On the DB case, Mr. Bernstein was appointed for conflict counsel on that.
And he's no longer here. Well, Mr. Bernstein is not here, or Stein. All right, we'll pass this for a moment. Mr. Bernstein just signed in, so I will go ahead and stay where I was. Mr. Bernstein, please enter your appearance with respect to the Christopher Caldwell.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Caldwell.
Thank you. All right, we're here for a sentencing and a pretrial. In the pretrial matter, there is a bond violation as well.
I believe that's correct, Your Honor.
The bond violation alleges that on March 9th, 2024, Mr. Caldwell apparently kept texting the complaining witness in this case, and there are text messages showing that he had been texting. That is the alleged violation, sir. If it is found that that is true, your bond could be revoked, and You're entitled to have a hearing in this matter. Mr. Bernstein, what would the client like to do?
Your Honor, I only connected with Mr. Caldwell like last night. Ms. McDuffie did send me the report timely, but I only connected with him last night. I really haven't had a long time to speak with him about it. It seems based on the email that I received that there could be potential charges that are coming forward as a result of the bond violation allegations. And I was curious to see if there was any more information about that. Because I think there'd be some interplay between how he moves forward and that. I don't know if there is any information on that. Ms.
I'm checking
McDuffie?
right now to see if that was assigned to anybody. One moment. This screen takes just a couple moments to load. It looks like I don't think that the aggravated stalking charges were authorized. I'm just waiting to see who reviewed it and what the reason was for denial. But it's still churning. But as far as I can tell, I just don't want to speak too soon because. Hold on one moment. Okay, yeah, it was denied, but I don't think that the person who denied it realized that there was the underlying case that would have supported the charge. So I cannot guarantee that there won't be charges coming because I have to go back and speak to that APA and the supervisor about that. But as of right now, it isn't charged.
Kind of in limbo then. Would the court indulge me 1 week to speak with Mr. Caldwell about it, Your Honor?
I'm going to adjourn both the sentencing and the bond violation until next week. Ms. McDuffie, will you be prepared to go regardless?
I should be, Your Honor. I just have to quickly check in. I think, yeah, I'll be able to check in with to guarantee what the status of this new report will be. And Mr. Caldwell also has a community corrections violation, I think, for failure to report for testing. I'm trying to look across all three of these cases to see if there are any allegations as well.
Sentencing is adjourned to April 1st, 2024 at 11 a.m. as well as the bond violations, both of them, they're in person.
Did you say in person, Your Honor?
I did.
Okay. I haven't been at 14B in like 5 years at this point.
Well, it'd be good to see you in person again.
I mean, I wish they were different circumstances, of course, but I'm happy to be there in person, Your Honor. Thank you.
Thank you.
I hope everyone has a great week.
You too. What? Ypsilanti Township versus MIWashington 24S00072, as well as 24T00038.
Your Honor, one of those is a state case. It has an OM on the end for some reason, but one of those is mine. Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Alexander Hermanowski with on behalf of Mazio McIntyre. Your Honor, this time and date set for pre-trial. Mr. McIntyre has a few other pending cases in front of this court that are set for pre-trial next Monday. I'm trying to see if we can work out a global resolution. I'm asking that it be adjourned until next week as well.
Mr. McIntyre, please unmute, have them unmute you so you can state your name, please. Any objection to the adjournment request?
No objection.
No objection.
Amazio, McIntyre.
Thank you. So that would be an adjournment to April, I'm sorry, to April 1st.
Yeah, I'm sorry, April 8th.
I'm sorry.
April 8th.
Okay. Pre-trials adjourned to April 8th, 2024 at 9 a.m. while discontinued.
Thank you very much.
Thank
Is
you.
that in person or by Zoom? Because now I'm confused.
It's by Zoom.
Okay, great. Have a great day.
You
Talk
too.
again.
Bye-bye.
Have a blessed day.
You too. Thank you. Ypsilanti Township versus Patricia C. Case number 23T00450.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Assistant Public Defender Dobby Lebo on behalf of Miss C. Miss C, could you say your name, ma'am?
Patricia Ann C.
Thank you. All right, in this particular matter, we're here for a pre-trial today.
That is correct, Your Honor. We had attempted to refer Miss C to mental health treatment court. However, she was not accepted from that due to some difficulty she had returning a phone call to set up her intake interview with MHTC. I did discuss with her, and what she's told me is that her phone was disconnected during that time period. She now does have it back on, and I have discussed this with Mr. Barnett, who tells me he's prepared to proceed with a re-referral for Miss C.
Yeah, I have no objection to a re-referral for her.
And we're certain that's the only basis for the denial.
Yes, Your Honor. And I did verify with Mr. Gravelin that they would consider a re-referral.
And so we are, will we need a new referral form?
Yes, Your Honor.
Are you going to send it over today?
I'm going to send that to Ms. Barnett for the signature, which I will then forward to the court, Your Honor.
Thank you.
Thank you.
Trial will be adjourned to April 29th, 2024 at 9 a.m. Bond is continued.
Thank you.
Thank you.
Thank you, Potter.
You're welcome. Have a good day, ma'am. State of Michigan versus Jason Roth, 24S00058.
Rachel McDuffie for people.
Assistant Public Defender Allison Mueller here on behalf of Jason Roth. Mr. Roth, can you unmute and state your name for the record, please?
Jason Roth.
Thank you. Good morning, sir.
Good morning.
We're here for a pretrial.
Yes, Your Honor. We would be asking for hopefully one last adjournment. I believe Ms. McDuffie had already requested the body-worn camera footage. That didn't come in yet, so we do want to see if that can come through. We'd like to that before deciding on how to proceed.
Pretrial will be adjourned to April 15th, 2024 at 9 a.m. Bond is continued. You're all set, Mr. Roth. We'll see you on the 15th of April. Ypsilanti Township versus Zaire Alberti, case number 24T00070.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Leba on behalf of Ms. Alberti. Ms. Alberti, could you say your name, please?
Zaire Alberti.
Thank you. We're here for a pretrial today.
That is correct, Your Honor. At this time, we would like to set this matter for a final conference.
Final settlement conference will be April 25th, 2024 at 11 a.m. Jury selection will be May 3rd. 2024 at 8:30 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. You're all set, Ms. Alberti. Have a good day.
You too. Thank you.
State of Michigan versus Gregory Corrigan, case number 24S00048.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Gregory Corrigan. Mr. Corrigan, can you state your name for the record, please?
Gregory Corkin.
Thank you. We're here for a pretrial today.
Yes, Your Honor. There has been an offer. Ms. McDuffie, I understand the offer would be to dismiss the domestic violence second and offer assault and battery. Is that the final offer on this matter?
Yes.
Okay. And then I did send a last email this morning, Ms. McDuffie. I know I sent that, just before the docket started. I would be interested in filing a motion on Mr. Corrigan's behalf. I did want to see if that offer would be remaining open if we were to file the motion.
Okay, I'm looking at it now. Honestly, I've extended the offer kind of against my better judgment, which I shouldn't do, but I will. I'll say yes for right now. I don't know if the terms will be the same though.
Okay, Mr. Corrigan, do you understand that the offer may somewhat remain? Not all terms may be the same. Do you still want to proceed with filing that motion?
Yes, ma'am.
Okay. Your Honor, if we could, we would like to file a motion on this matter on the issue of whether or not Mr. Corrigan's statements to police should be suppressed.
Thank you. How long will you need to get it filed?
I'm sorry, Your Honor, what did you say?
How long will you need to get that motion filed?
Your Honor, if I could have, a week and a half or 2 weeks, that would be great.
Why don't we schedule the hearing on April the 29th at 11 a.m.? You can have yours filed by April 8th. And the prosecutor's response by April 22nd.
Thanks, Your Honor.
Thank you.
And I will see you all back here on April 29th for the pretrial and motion hearing. Thank you.
Thank you.
Yeah.
State of Michigan versus Tony Mosby. Case number 23S00538.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Tony Mosby. Mr. Mosby, can you have the jail unmute you and state your name for the record, please?
Tony Mosby.
Thank you. Good morning, Mr. Mosby. All right, we're here for a pretrial and bond violation. Mr. Mosby has been held on a 10% bond in this particular case for failing to test.
Yes, Your Honor, and we are prepared to proceed on both. As to the pretrial today, Mr. Mosby would like to move forward with a plea as charged. And as to the bond violation, we will be admitting to the violation. Just with perhaps a brief explanation of what's been happening with Mr. Mosby, and I'd like to address bond if possible.
And just to be clear, Mr. Mosby previously admitted to, I believe, a sober link violation in January, but there's a new positive on 2/26.
Yeah, I believe on the 15th, we admitted to that first positive, and then, like you said, the second positive did come after that first admission.
The second positive is that he was positive on February 26, 2024 at 9:25 p.m. And then he failed to retest and didn't retest again until 9:42, and he was still positive at 0.107.
Yes.
Then he has missed every test since February 27th, it appears. Sir, do you understand your right to have a hearing on these matters? It's my understanding you're going to waive your right to have a hearing, and you also want to plead guilty as charged to the operating while intoxicated. Is that true, sir?
Yes.
All right. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. Let's start with the pretrial first. Sir, it's my understanding you're going to admit guilt to operating while intoxicated. That is a misdemeanor. It carries a maximum penalty of up to 93 days and up to $500 plus court costs. Do you understand that, sir?
Yes.
I'm going to go over some rights you have that you're going to be giving up by entering into this plea. Please stop me for questions, or if you feel like you need to speak with your attorney again, okay? Is that a yes?
Yes.
Okay. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses to come to court. You have the right to see, hear, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
You understand you're not giving up all those rights, and that you're not going to be having a trial of any sort?
Yes.
And do you also understand that there's no automatic right to appeal this decision? So the decision you're making today, in all likelihood, is going to stick with you.
Yes.
And if you were on probation, parole, or bond on May the 20th of 2023, when this occurred, you could be in violation of that probation, parole, or bond. Were you on any of those?
No.
All right. And then if you're not the U.S. citizen, you could be considered in violation of immigration laws and have repercussions. Are you a U.S. citizen?
Yes.
All right. To the charge of operating while intoxicated, how do you plead?
Guilty.
Has anyone promised you anything other than what we placed on the record today to get you to plead guilty?
No.
Has anyone threatened you in any way, shape, or form?
No.
All right. On May 20th, 2023, we're operating a motor vehicle at the vicinity of Ford Boulevard and Russell Street here in Ypsilanti Township.
Yes.
And at the time you were operating that motor vehicle, were you under the influence of alcohol?
Yes.
All right, counsel, was there a BAC test?
There was, Your Honor. I have a blood result of 0.174.
Thank you. Do you stipulate to that, Ms. Muller?
Yes.
I do, Your Honor.
I find that there's a factual basis for the plea, and it has been willingly and knowingly made. Are you satisfied, Ms. McDuffie? Ms. McDuffie?
Your Honor.
Ms. Muller?
Defense is satisfied as well. Oh, yes, Your Honor.
And as to the second bond violation, sir, is it true that you tested positive for alcohol on February 26th at 0.023 and then later at 0.017 of 2024?
Yes.
All right, I find that there's a valid basis for that plea as well. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms.
I'm
Muller?
satisfied as well, Your Honor.
Thank you.
Yes, thank you.
All right, you wanted to address bond?
I do, Your Honor. I understand that, and I think this is linked to the bond violation that Mr. Mosby just admitted to. It sounds like he's been going through, has had a home situation that I believe may have ended. I'm not sure if he has a new charge now. I believe he does. But in relation to that incident, Mr. Mosby does have a few stab wounds. And that occurred on March 11th. He was in the hospital for about 7 days. I realize that the sober-link violations occurred before that. He does have several injuries that he's still recovering from. So him and his, I believe, ex-partner have now separated because of that incident. I think what was going on with his partner, the alcohol was related to that, what was going on there. Mr. Mosby does say he's in a better space now. They have separated. He in connection with his hold in Wayne County. I think he has a personal bond on that, but he will be put on a GPS tether. So my ask for the court would be that Mr. Mosby is allowed out on this case as well on a personal bond with that GPS tether that he'll have out of his Wayne County case. And then we would request that Mr. Mosby be put on a scram tether. Mr. Mosby I think what was going on there led to some of the stresses. After he had the second positive, he said that, he was just scared. It was turning out positive again, and he didn't want to continue with the sober-linked device. He is in a better space now. His home life will be calmer. He does want to comply with the conditions ahead of sentencing and possible probation, if that's what he's sentenced to.
Ms. McDuffie?
Well, that was a lot. So one, I guess, for Ms. Muller, and I just want to be clear. So Mr. Mosby, the case that he has pending in Wayne County, I see that there was a GBH and a domestic violence second offense with an offense date of 12/31 of 23. You're not referring to that, or is there something newer than that?
Oh, I'm sorry. Can you say the offense date again?
12/31 of 2023.
Okay, so that is what's pending out of Wayne County. So I think maybe then, I don't know how this ties into his injuries that he just received were just on March 11th. So maybe I misunderstood Mosby. I thought maybe he had pending charges from what happened that put him in the hospital, but it sounds like maybe that was unrelated. So he's on Mr. Mosby. Is that correct? I'm sorry. I think I've misunderstood.
Everything that I went through is because of this what I'm going through right now. It was related. All of this was related together.
Okay, I don't want him to say anything about any of his pending cases here in Wayne County, but I was just trying to clarify basically as to whether we had a bond violation here with that case. So that case that I'm looking at would not be because he was arraigned here in January. So I'll just leave it at that. And if something else comes up, it comes up and we'll deal with it then. Now,
yeah, thank you.
Bond, sure. As the bond in general, Mr. Mosby, I'm still concerned about the things that happened before any sort of intervening, I don't know what that situation was that he's describing, but in the underlying case, we have him rear-ending somebody's vehicle at a very, I don't want to say a very high rate of speed, but it was with a lot of force. And so much that, the driver of the other vehicle actually took the keys out of Mr. Mosby's hands on the scene because he was drugged there. Mr. Mosby had a previous high BAC in Wayne County that was just 2 months outside of the window where this would have been enhanced to a second offense. So clearly there's a problem. And the first positive test we had with the mouthwash excuse, which we hear all the time, we're back here again. So the fact that Mr. Mosby doesn't seem to really, I don't know that he has insight into his problem. I understand he's associating this with some other things going on, but I don't know that he truly gets how bad this problem is for him. Given that we had the mouthwash excuse before, I'm going to leave it to the court in terms of potentially releasing him on bond, but I don't. Scram versus SoberLink. I usually prefer SoberLink because we get those results right away. Mr. Mosby hasn't been doing well, but that actually makes me want to keep him on the SoberLink. So I don't know. I know he needs to be assessed as soon as possible, and probably in some sort of treatment, but I don't have anything to offer beyond that.
All right, well, the reality is that Mr. Mosby, I don't know if what I just heard about his home life gives me any consolation that he's in a better space. I understand what you're saying and I understand his injuries. And right now, I can't figure out whether he was the aggressor or someone else was. Those are all very concerning situations for me. Can I see probation and counsel in a breakout room? All right, we're back on the record in the Tony Mosby matter. I'm going to pass that matter for a moment to allow probation to make contact with our assessor to find out some details before I make a decision regarding the bond. The court will call the matters of the state of Michigan versus Joshua Broughton, case number 23S00831, as well as 23T00808.
Richmond, Deputy from the People.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lebo for Mr. Broughton. Mr. Broughton, could you state your name, sir?
Yes, my name is Joshua Broughton. How y'all doing today?
I'm good, sir. Thank you for asking. All right, we're here on 2 pre-trials today.
That is correct, Your Honor. I believe we have a resolution in both these matters. With regard to the no proof of insurance, I believe I have provided proof of insurance to Mr. Barnett.
Okay. Mr. Barnett?
Yes, that's correct, Your Honor. So I'm prepared to dismiss this ticket at this time.
Thank you.
Thank you, Ms. Barnett.
All right, that matter is dismissed at the motion of the prosecution. As
Thank you,
far
Your Honor.
as
With regard to the fourth degree child abuse matter, Mr. Brown will be accepting an offer to plead guilty as charged with a prosecutor's deferred sentence and an agreement to a term of probation as determined by probation.
all right, I'm just writing it out. Is that a correct statement of the agreement, Ms. McDuffie?
That's correct.
Thank you. Mr. Broughton, it's my understanding that you are going to be pleading guilty as charged to a count of child abuse 4th degree, that is a misdemeanor carrying a maximum of up to 1 year in the Washtenaw County Jail with probation up to 5 years. Do you understand that, sir?
Yes, I do.
And that's what you want to do? It's under a deferred sentence?
Yes, I was.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. I'm going to go over some rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
All right.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses. And you have the right to require that, you have the right to testify, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, I do.
You understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
Yes.
You also understand that there's no automatic right to appeal this decision. So the decision you're making today, in all likelihood, is going to stick with you.
Yes.
And do you also understand that if you're on probation, parole, or bond at the time that you committed this offense, which was on November 9th of 2023, and you still are, then you could be in violation of that probation, parole, or bond?
Yes.
Thank you. And in addition to that, sir, if you're not a U.S. citizen, you could have immigration consequences.
No, I'm a citizen.
Okay, thank you. To the charge of child abuse, 4th degree, how do you plead?
Guilty.
Has anyone promised you anything other than what we placed on the record today to get you to plead?
No.
Has anyone threatened you in any way, shape, or form?
No.
Right. Let's turn to the date of offense itself. On November the 9th, 2023, were you at the vicinity of 1468 Share Avenue here in Ypsilanti Township?
Yes, I was.
And at the time you were there, did you knowingly or intentionally create a circumstance that posed an unreasonable risk of harm to a child?
Yes.
You left that child alone without supervision, who's 2?
Yes.
All right. I find that there's a knowing and willing admission to or of guilt to the violation. Are you satisfied, Ms. McDuffie?
The people are satisfied, Your Honor.
Defense is likewise satisfied, Your Honor.
Thank you. Sentencing in this case will be on April the 22nd, 2024 at 10 o'clock a.m. Sir, you need to make and keep an appointment with the probation department. Do you have their?
Well, I'm not on probation or anything right now, so I don't have any information for them.
Okay, I'm gonna give you the number now, and that's gonna go for anyone else that's on this call that might get referred to probation. So please get a pen and write it down.
Okay, give me 1 second. Okay, what's the number?
734
Mm-hmm.
483 7336.
7336?
Yes.
Okay. So do I get in contact with them or they will reach out to me?
You need to call them tomorrow after 9 o'clock a.m.
Okay. All right.
All right, and you need to do that because you're gonna get referred for, nope, you need to do that because they're gonna set up a time for you to have a pre-sentence investigation interview, and that needs to be done before you come back here for sentencing. You need to call them tomorrow so they can get it done in time to give a report, okay?
All right.
All right. Thank you, you're all set, sir.
I have one more thing, Your Honor, if possible, if I could speak.
Yes, sir.
Okay, so this doesn't have anything to do with my case particular, but I do have my girlfriend that has a court date with you today. She probably gonna be on Zoom with you in a few. It was pending against me, but I just wanted to say I asked the prosecutor and I sent the letter out and everything to say I wanted to drop all charges, so hopefully you can hear my word. But I know this doesn't have anything to do with this case right here, but it is a case that has something to do with me and her that's coming up with you soon.
Mr. Broughton, the truth of the matter is that you don't get to decide whether it's going to proceed anymore. That's up to the prosecutor.
All right, I do thank you. Though I just wanted just to pick that word out if possible.
All right, thank you. I'm sure Ms. McDuffie has heard you. All right, thank you.
I can leave now?
Yes, sir. Have a good day.
You too.
State of Michigan versus Christopher Steffens, case number 97S00661.
Rachel McDuffie for the people.
Assistant Public Defender Davi Libo for Mr. Stevens or Steffens. Sir, could you state your name?
Christopher Michael Stevens.
Stevens. Thank you, sir. Good morning.
Yes, ma'am. Good morning.
All right, we're here in this particular matter for a set aside, an application to set aside the conviction.
Yes, ma'am.
I'm going to swear your client in, Mr. Lebo, and then you can make out the factual basis for the actual application to set aside. Please raise your right hand, Mr. Stevens. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may proceed.
Thank you, Mr. Stevens. Is it true that you have only had one prior conviction expunged?
Yes, ma'am. Or yes, sir. I'm sorry.
And that was a nonviolent felony. Is that correct? My apologies.
Yes.
A nonviolent misdemeanor. Is that correct?
Yes, sir.
Thank you. Thank you. And you have received a letter from the Attorney General indicating that there is no opposition.
Yes.
Thank you. And since 1997, then you have not had any further criminal convictions. Is that correct?
That is correct.
Thank you. And could you tell the court a bit about what you've been up to since 1997?
Since 97, I've become permanently disabled. Suffered a back injury in 2004. I was a high school dropout, but in 2020, I went back to school and graduated with a high school diploma. And we have been in foster care, adopted 2 kids, and that's the reason for requesting to set aside so we can get back into foster care.
Thank you, sir. Your Honor, I believe that does satisfy the requirements for an expungement.
Ms. McDuffie?
Your Honor, the people do not have any objection to this application. I think that I just want to clarify, his prior was a felony, but it was nonviolent, but that was the B&E.
Yes, it was a B&E that was originally supposed to have been dropped at the time of trial to a misdemeanor, but for some reason it was put on as a felony on my record. And after we started the process of having it expunged, they did reduce it to a misdemeanor before it was expunged or set aside.
Okay, that won't affect us here. So I just wanted to check on that. Thank you, sir. No objection.
No, that's fine.
I had one more question.
Yes, ma'am.
One moment. I have a sneeze that's sort of pending. But the question I have is, you don't have any criminal charges that are pending at this time. Is that correct?
No, ma'am. No,
All right.
ma'am.
All right. Well, it sounds like, and I did get your letter, which was a part of your packet, as well as some I got your piece regarding your high school diploma and your adoption paperwork, and your foster parent proof. So I have all that documentation as well. I find that you do satisfy the requirements here, and that I appreciate your rationale behind wanting this at this time, and I appreciate that a lot. So I will give you and your family that opportunity, and hopefully you do what you need to do in terms of taking care of these children. And I'm glad to hear that your adult children are doing well. So that's really good too.
Thank you.
And I am honored to be able to give you a second opportunity, sir. And I will grant your application.
Thank you.
You're welcome.
Thank you, Ron.
Congratulations.
Thank you. You folks have a good day. Thank you.
You too. You're all set, sir. Have a good day.
You too. Thank you.
Ypsilanti Township versus Ahmed Alexander, 23T00361.
Paul Barnett on behalf of the township.
Mr. Lebo is in a breakout room? Is in a breakout room, so is there anyone who can handle this matter?
Yes, Your Honor, sorry about that. Assistant Public Defender Allison Mueller here on behalf of Ahmet Alexander. Mr. Alexander, can you state your name for the record?
Ahmed Alexander.
Thank you. Good morning, Mr. Alexander.
Good morning.
All right, we're here for our sentencing today.
Yes, Your Honor, and looks like Mr. Alexander does want to accept the recommendation from probation. The client, Mr. Alexander, excuse me, intends to complete his community service at St. Andrew's Food Program. Mr. Alexander has learned a lot from this and now understands that he needs to have a healthier relationship with substances. He understands that operating while intoxicated is very, very dangerous. He does request, if possible, that the tether be removed. He's had no scram violations at all since his release. And that's all, Your Honor. Thank you.
Thank you. Ms. McDuffie.
It's actually my case, Your Honor.
I'm
I've
sorry.
reviewed the pre-sentence investigative report and recommendations. I think they're appropriate. I ask you to adopt those.
Ms. Mueller, how long? Do you know how long he's... So he's only been on the scram since December 22nd?
I believe, Your Honor, is that right, Mr. Alexander?
Correct.
All right, thank you. Anything you want to say, Mr. Alexander?
Just thank you guys for your time. Learned a lot during this whole case, and I'm really apologetic about, drinking and driving, and I accept the full, responsibility for my actions, and I'm ready for rehabilitation, classes, community service, and everything that entails. I paid off all the 14B fines and costs, I believe, associated with the rest of the recommendation, and yeah.
Thank you. I do appreciate you paying off all the rest of those. I was informed of that this morning because they were no longer on my docket, so I appreciate you doing that. How are you going to manage these warrants? You've got 5 warrants outstanding. You got one 18th district, one from 34th, 2, 3. Let's see, 4 of them are from the 34th district court right down the street here in Romulus. So you got those 4, and then you have the other one from Westland. What is your plan regarding them, sir?
Correct. So I just didn't want to violate any type of, if I turned myself in, it might have went with this case. So I decided to wait till, sentencing to get that done. So moving forward, I was going to find a day, because I work pretty much Sunday through Thursday, find a day just in case they hold me, because I don't think I'll have the bond money, but pretty much they're just driving violations, no proof of insurance, registration plate. So I was planning on paying the tickets off. It's about $1,200, and then going up there and seeing whether they're going to hold me until I can see a magistrate. And then I think there's one more for driving on suspended license.
Okay. All right. And then the only other question I had for you is that, the report was very clear that if this was a first offense, you probably wouldn't be placed on probation right now, but it is not a first offense. So I'm trying to figure out, what have you learned differently this time than you did the last time? Because we're back here again. And driving seems to be one of your biggest downfalls, it appears, because that's why those other things are going on. So I just don't want you to be here again. And the next time, if there were one, you may not be so lucky, and maybe neither does some other citizen riding down the road, and that's a huge concern for me. So is there anything you want to say regarding that? You don't have to.
Yeah, this is my first alcohol-related driving offense. Like I said, I apologize. It wasn't.
I see. The other one was just substance related. It was not a driving. I think he's frozen.
I'm sorry. Oh,
The
okay.
other
Yeah.
just substance related. It wasn't a drug situation. Okay. All right. Thank you for clarifying that. I do
Okay.
see. All right.
Yeah.
All right. I'm gonna follow the recommendation of the probation department. It is the sentence of the court, sir, that you serve 93 days in the Washington County Jail, credit for 6 days served. The balance of that time, the other 87 days are suspended, meaning that if you do what you're supposed to do, then you don't have to do any jail time. You are on, you have to do 6 months of community, 6 days, 6 days of community service for a total of 48 hours, 12 months on probation, fines and court costs in this case for a total of $625, $30 per month probation oversight fee, complete the armed DUI course within 90 days, attend the MAD victim impact panel within 45 days, provide a certificate of completion to the probation agent. You to report to the probation officer monthly via the online reporting platform, meet with probation when and where directed, including any and all home visits. There's no use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, firearms, firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone using those. You to drug and alcohol test 3 times per month, and any other times it's ordered by the court, probation, or any police agency. You to attend 10 open 12-step meetings in person and provide proof of those. And you're to clear all the bench warrants within 90 days. We'll do a review with this court on June 24th at 10 o'clock a.m. The scram tether will come off at this point, so you just want to be testing, okay?
All right.
You need to contact the probation department tomorrow after 9 o'clock a.m. I hope you wrote down the phone number when I gave it out earlier. Did you, sir?
Yes, Your Honor.
Thank you. Please call them tomorrow after 9 so you can sign your probation contract, okay?
All right, will do. Thank you, Your Honor.
Have a good day.
You too. Thank you.
Honor.
All right, the court will recall the matter of the state of Michigan versus Tony Mosby, case number 23S00538.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Tony Mosby. Mr. Mosby, can you have the jail unmute you again, please, and state your name for the record?
My name is Tony Mosby.
Thank you. All right, I've received some information about this particular matter. I'm going to grant a $25,000 personal recognizance bond with the stipulation that Wayne County's tether must be placed before he can be released. And he must continue on the sober link. I'll bring him back here on April 29th, 2024 at 10 o'clock a.m. for sentencing. Sir, you must get your assessment done. By April 15th. If you don't have it done by then I'll consider that you're not gonna have it done and I'm gonna issue a bench warrant. Okay?
Now I have one question. What's the assessment?
You can talk to your attorney about that, sir.
Okay, thank you.
Go in a breakout room with him at this time, Ms. Mueller?
Yes, Your Honor, if I could, thank you.
Is Sandra Law your case?
No, that's, I believe, Sandra White's case.
Thank you. We'll put you in a breakout room at this time. The court will call the matter of the state of Michigan versus Sandra Law, case number 22-00563.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Sandra Law. Ms. Law, can you unmute and state your name?
Ms. Law, you need to unmute your device. Please state your name, ma'am. All right, there's a bench warrant that was issued for Ms. Law when she failed to appear for sentencing on March 14th, 2024. At the time, she indicated that she had some medical issues that prevented her from being present. However, the letter was not particular enough for this court to agree to allow her to have adjournment at that time. Since that time, some additional letters did come into the court, which combined sort of explained why she was not able to determine what the chronic illness was at the time. So I scheduled it for a hearing today for her to be arraigned and for the prosecutor to have some opportunity to discuss her position with respect to this and for me to make a ruling on it. Having said that, Ms. White, what would you like to say on behalf of your client before I go to the prosecutor?
I would ask that the warrant be recalled, and that, as the letter has stated, Ms. Law has been suffering from different chronic illnesses for the better part, it sounds like the better part, most of this year, from what Ms. Law has told me, and that the court does take that into consideration and do recall the warrant.
Ms. McDuffie?
Your Honor, I am also in receipt of those letters. I see that they explain, well, I'm not exactly sure what they explain. They mentioned some specific dates in February and mostly March. I think these are supposed to be explaining her absence from the last pretrial, but we still have some outstanding issues. So when she was last here in person in court, the issues were that she had not yet, for some reason, that ROI was with Higuera was not done, and it appears to still not be done. So I'm not really sure what else to do about that. We also had the issue with her test. Now, I understand that her letters and her illness might explain a couple of missed tests, but even before that, what I had raised is that we did not have any prescription information that might explain some of the substances that showed up in those tests. And the prescription information that I was given still doesn't explain that, because those documents are dated as of August 15th of 2022 and October 18th of the 25th of 2023, which does not account for the results that I have from February of 2024. So I'm still lacking current prescription information that would potentially explain the positives, and obviously community correction should have that as well. And
there is a letter that talks about the February 19th to February 23rd. Do you have that letter?
Is it for the absences or her illness?
It's for, she was seen in the clinic on the 20th, and they asked her to be excused for February 19th through the 23rd.
I'm just referring to the prescriptions. We had the positive opiates and amphetamines on February 5th and 16th, and we were supposed to be getting a current prescription to show that she was still prescribed those. So I'm still waiting on that because we haven't fully resolved all of her missed tests. And then this may explain again, right? Obviously, the most recent set of missed tests from the 23rd through the 6th, but we obviously have a very long list of missed tests before that from last November through the end of January. So we still have some underlying issues, but I think most importantly, that assessment is still not done, and I'm not sure what's going on with that ROI.
The assessments weren't done due to the conflict of interest when she went to go get the assessment done, and they found out that the therapist they knew each other, so she was supposed to get a new assessor, and she's in the process of doing
about that. What are you referring to?
They're supposed to get a new therapist. I'm sorry, I didn't hear what Your Honor said.
I don't understand what you're saying.
Your Honor, I could clarify that if.
Thank you.
Okay.
So Ms. Law completed an assessment. However, the therapist that completed the assessment did have a conflict of interest with Ms. Law. They were in the process of assigning her a new therapist to begin the recommended treatment. And I had asked a couple of times now for that assessment to be sent over to me. I still have not received it, and I don't have any other update on if she did actually get the new therapist assigned and start her treatment, or where we're at this point.
So an assessment has been done.
Yes.
But with respect to the treatment going forward, she was going to get a new person due to a conflict there.
Yes, Your Honor.
Okay.
And they were going to send me the assessment. They told me a couple of times now, and I still have not received it.
All right. So we do have an assessment.
Yes,
We don't have
that's
it,
my fault.
we don't have it, physically have it. We know that there is an assessment that's been done.
Yes.
Okay. All right. Thank you.
Thank you. I said that wrong. Thank you, Ms. Straub. And the last thing I talked to Ms. Law about that, I think because she's been so sick that she hasn't been able to meet with a therapist either, but she is waiting on a new therapist. Is that correct, Ms. Law?
They just
Okay, just say yes or no. I know you can't speak very well.
Yes.
Okay.
All right, Ms. McDuffie, given that new information, what is your position? I know that does not address the positives, but sounds like she is not well still.
Oh, yeah, I have no doubt that Miss Law is sick. So that's never been my concern that she was not being honest or faking that. It's just that we aren't able to get things accomplished here. I don't have an issue with adjourning the bond violation as it relates to the testing and the positives, but I'm going to make another request. We have successfully gotten the letters. So if we can just try one more time to get some information on her current prescriptions, I'm going to make one more request for that.
All right. I'm going to recall the bench warrant in this case, and the bond is reinstated. Sentencing will be April 15, 2024. Defendant must provide proof of prescriptions by that time. And the assessment. I'm sorry, I'm wrong. I'm going to make that 11 a.m. and that's in person again.
And that was April 15th?
Right.
Thank you.
Thank you.
Speak.
Court will call the Muhammad Diane matters 21W00731B and R, as well as 23W001986.
Paul Barnett on behalf of the township.
Assistant Public Defender Don Viliba for Mr. Diane. Mr. Diane, could you state your name, sir?
Mohammed Diane.
Thank you, Ms. Diane. All right, Mr. Diane is here for payment plan reviews. Has your client been making any payments?
He is not, Your Honor. However, Mr. Diane has told me that he's going to be able to resume a $25 per month payment plan beginning on the 1st of April and would like to do that on the 1st of the month going forward.
I think Mr. Diane says that every time he comes to court. Is your client working?
Mr. Diane, are you employed at the moment?
No, I'm not.
Are you looking for work, sir?
Yeah.
June 3rd, 2024 at 10 a.m.
Thank you, Your Honor.
Mr. Diane, you need to get a job, start making payments on your matters, or I'm gonna have a hearing to determine whether or not you are capable of making payments and working. And if you're found to be able to do that and you're not, you can be held in contempt of court. Do you understand that, sir?
Yeah.
All right. June 3rd, 2024 at 10 a.m. I will call the matters of Deontay McDaniel, 19S00010 and 19S00176.
Rachel McDuffie for the people.
Assistant Public Defender Davia Leva for Mr. McDaniel. Mr. McDaniel, could you please unmute and state your name, sir?
Deontay McDaniel.
Thank you. Good morning, sir.
Good morning, Chief.
All right, so we're here today for sentencing on a VOP.
That is correct, Your Honor.
Mr. McDaniel turned it around, I see.
He did, Your Honor.
Thank you, sir.
You're welcome.
He completed the program. I saw him in January. And at that time, he was on step 7, and he needed to provide the proofs. Of completion, he did that. Still hasn't made any payments yet.
Yeah, I'm working on that right now.
Mr. McDaniel is currently looking for work, Your Honor.
All right. What is your request today?
Your Honor, I asked that Mr. McDaniel be simply reinstated on his probation and that we be given a review date for Mr. McDaniel to begin making payments after he's found a job.
Ms. Johnson.
Good morning, Your Honor.
Good morning again. On Mr. McDaniel's matter, I know that his original date was supposed to be April 10th, but he was in violation for a while, or was he in violation for any period of time?
I looked to see if he was in violation for any period of time, and I don't think that we had any additional time that we can extend him for, because it looks like he was present while he was in violation status.
Gotcha.
Because we did the violation, but he appeared for the next court date, so he wasn't like in actual warrant status where he was absconded.
Thank you. This is what I'm going to do. I'm going to adjourn the sentencing to April the 15th, 2024 at 10 a.m. to see if you've started making some payments, sir. If you start making some payments, then there may not be any sanctions because you can show this court that you took this very seriously. And we'll go from there. Okay?
All right.
So,
thank you.
then we'll just discharge you and have you come back for payments only. So get a job and make some payments towards your fines and costs. Okay?
Okay, I will. Thank you.
See you on April 15th at 10. State of Michigan versus Eric Overby, 24S00082, as well as 23FB1011.
Rachel McDuffie for the people.
Assistant Public Defender Don Lebo for Mr. Overby. Mr. Overby, please state your name, sir.
Eric Overby?
Thank you, Mr. Overby. All right, we're here on a pretrial and a violation.
Yes, Your Honor, with regard to the violation, Mr. Overby will be pleading guilty.
Mr. Overby,
Yes, Your Honor.
I'm sorry, Your Honor. Mr. Overby's violations consist of the incidents in his new impending pretrial as well. So I just wanted to clarify, what is he admitting to exactly?
Thank you, Ms. McDuffie. I do want to clarify that. Mr. Overby is prepared to plead guilty to the violation with regard to the leaving treatment early.
no, we're not gonna do that today. We're gonna find out whether or not he's guilty of his new offense first.
Yes, Your Honor, with regard to that, I would like to request an adjournment. I did have a brief conversation with Ms. McDuffie regarding the new offense, and I would like to discuss that with Mr. Overby a little bit further.
McDuffie?
Your Honor, that's fine. I discussed with Mr. Lebo that, as I just mentioned, these are obviously very intertwined incidents and resulting in him being placed in custody now. There's a lot of layers of violations with involving no contact, obviously the consumption of alcohol, and just a number of things. I don't have any offers to extend, obviously, I think given the circumstances here, except that, and that still is up to the court and probation to approve. All I could suggest was actually upfront jail versus probation because Mr. Overby is not able to handle probation supervision and that he needs to stay in custody for the duration of the sentence. These are both 93-day charges, his probation and the new case. So I don't have any problem with the adjournment. I'm sure he'll want to address bond.
All right, I will adjourn these matters to April 15th at 9:00 a.m.
Thank you, Your Honor.
Bond is continued. All right, it looks like we don't have anything else that we can call just yet, except for in-persons.
Well, no, we have one person who's in person, we said the rest of our jail people lined up.
Oh,
So that I don't put them in for.
okay. So we have one person who's present for in-person. Mr. Harrison,
Okay, I'm on my way down.
thank you.
Oh, Your Honor.
Yeah.
There's a case on I don't think that defense counsel contacted the court. I communicated with her late
They
last.
did contact the court, but they didn't provide a stip. They provided a motion.
Okay, I wasn't sure if you got that because I got
Let's
it last
call
night.
that now. while
Okay.
She comes down. Court will call the matter of the people of the state of Michigan versus Zantia Jackson Poole, case number 24 FB 1004.
Rachel McDuffie for the people.
Miss Wendy Barnwell has filed an appearance in this case and then a motion to adjourn it all at the same time. The defendant has posted a $500 bond, but apparently the defendant is not present here today either. Ms. McDuffie, you may proceed with whatever information you may have.
Thank you, Your Honor. I reached out to Miss Barnwell last night. I knew her from a couple years ago, and she indicated, as I think she stated in the motion, that she is in a baby death trial. She called, that's been going on for quite some time. I'm not clear on how long it's anticipated to continue to go on and what date she was looking for. Ms. Jackson Poole is no longer in custody. I don't have any issue with the adjournment. She does not have a discovery because she hadn't filed that appearance with our office either. So I expect that she's going to need some time to not only finish her current trial in this other matter, but to get discovery and meet with her client. No objection to the adjournment in their absence, because I don't think Ms. Barnwell knows how things work over here. So I don't have any issue.
The other thing I will say is apparently the defendant did try to sign in today, but was not allowed into the courtroom because there was a misunderstanding that there was a stipend order in place, and there is not. I will adjourn this to April 22nd, 2024 at 9 a.m. Bond is continued. We'll be on a brief recess while we set up for the in-person.
All rise. 14B District Court is now in session with the Honorable Lorraine C. Washington presiding.
Thank you. You may be seated. Court will call the matter of the state of Michigan versus Michael Harrison, case number 20FB 1834.
Rachel McDuffie for the people.
Please come down and come through there, sir.
This is Public Defender Sandra White on behalf of Michael Harrison, who's making his way to the front.
Thank you.
Michael Harrison.
Thank you. All right, we're here today for a violation of probation matter. Defendant pled to this violation back on January 18th. He was sentenced on that one. All right, he was arraigned on a new violation before the magistrate on March 20th, 2024. And there's currently a no bond bench warrant that still exists for the defendant. The allegation is that he has continued to fail to report for his anger management class. It appears that so has he been re-referred? All right, he's attended his first of he attended the first 4 classes. Is that correct?
He was re-referred and he is now scheduled to attend, Your Honor.
Okay, when is it supposed to start?
Yes. Is that correct?
Yeah, next Tuesday.
Next Tuesday. So his probation needs to be extended for him to get this done. It appears that, I'm not gonna extend it. Either he's gonna get it done or he's gonna do some jail time. I mean, that's the bottom line. You're gonna get it done this time,
Yes,
sir?
yes, absolutely.
April 29th, 2024 at 10 a.m. Nope. 11 a.m. in person. If he's gotten it done and provided the proof, please cancel the court date. Okay. So that means if you're back here, you haven't done what you're supposed to do. All right. So hopefully this is our last time seeing each other. All right. Have a good day, sir.
I'm sorry, Your Honor, and the bench warrant has been
Good
called.
morning. Recall. All right. State of Michigan versus Nicholas Sanford, 22F00276.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Nicholas Sanford.
Nicholas Sanford.
Hello, Mr. Sanford. How are you, sir? I'm good. You make it sit. All right, back on February 1st, Mr. Sanford was before me here, I think in his very room where he was arraigned on the violation of probation, and he admitted to that. and he was ordered to get the assessment. It appears that he has done that. We got the results from GrowthWorks, and based on that, your agent is willing to give you another opportunity. We will extend. Is there anything from the prosecutor before I send it?
Nothing from the people.
I'm gonna.
Nothing.
I didn't think there was. So we continue your probation, extended for 6 months, give you a new end date of December the 13th, sir, of 2024. I'm gonna do a review in 60 days on June 3rd to make sure you're still doing what you're supposed to be doing. Okay? So hopefully we don't have to see you back here again.
Yes.
Is there anything you want to say today?
This new program that I'm attending is free, and it's 3 hours a week, one person or two group, and it's yeah, it's actually closer to home, so it works better for
everything.
my situation here.
Good. All right.
Appreciate it.
Thank you, sir. Please try to get what you can get from that program. It's designed to try to help you. Okay. All right, you're all set.
Thanks.
You're welcome. It'll be on Zoom, sir, unless you do something wrong. Then I'll see you on Zoom. Thank you. State of Michigan versus Mauricio Weatherspoon, 23S00785 for a pretrial conference, and 24T00022 also pretrial.
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Mauricio Weatherspoon.
Mr. Weatherspoon, please get them to unmute your device and state your name.
Mauricio Weatherspoon.
Thank you. Good morning, sir.
Good morning.
Your Honor, in this matter, Mr. Weatherspoon and I were prepared to move forward, but Mr. Barnett may have an offer for us that he wants to consider. So I'm asking for a 1-week adjournment so that because Mr. Weatherspoon is in custody, we wanted to know if Your Honor would consider a PR bond, but due to the pending new case, I do need to investigate where he can be PR to. So that's another reason why I'm asking for a 1-week adjournment.
No objection to an adjournment.
I'm not willing to reduce the bond at this time. I'll allow you to bring that back up next week.
Okay.
Okay.
Mr. Weatherspoon, do you understand what's happening?
No, ma'am.
I know we had discussed moving forward, but there may be an offer. So we're going to adjourn for 1 week, and Your Honor said no to any type of bond reduction.
So I'm going to send you for a year.
No, we talked about that.
No, it's for 1 week, sir, so she can talk to you about what the prosecutor's offering, and you just can make a decision as to which direction you want to go in. And she can bring back any motions for bond before the court next week, okay?
If it's
Do you understand that?
Can I get bonded to my sister's house?
Not today, sir. Like I said, next week we can talk about that further. Okay? I'll see you all next week at 9 a.m.
Thank
you. You're all set. You can let them know you're all set, sir. We're gonna go back on. As opposed to count. All right, I'm gonna handle some failure to appears while Ms. White goes back over to her office. State of Michigan versus Daniel Cox, case number 18S00874.
Rachel McDuffie for the people.
It appears that this is supposed to be a motion for destruction of the biometrics that was filed by Mr. Cox.
Your Honor, I'm not sure that that's all it was based on the notes I have from our office and the context that we've had. It looks like he wants to challenge a number of things. But I'm not sure how much else I should say.
So you must have some information that I don't have, because all I have, well, let me see. No, all I have.
I can tell you what the court does know is that when he had a case pending in this court, he was found incompetent. And I think that for a time they were waiting for a bail. I don't know where he is now, but we have received a number of communications from him in our office. I think I can leave it at that.
Given that the court one second. Just trying to figure out how this got on my docket. It's notes. All right. All right, I'm gonna need to pass that for a moment. The court will call the matter of the state of Michigan versus Teal Jackson 22S008, no, 00671.
Rachel McDuffie for the people.
Assistant Public Defender Davi Leba for Ms. Jackson. Your Honor, I've not been able to have contact Ms. Jackson. In my last contact with her, she was in transitional housing.
Which one?
My apologies, Your Honor. Which one? Which transitional housing?
Housing was she at? Yes.
I believe it was Halo.
Well, she's definitely not there anymore, so we don't know where she is, in other words.
I did try to call her. Unfortunately, the number I had was disconnected.
Anything from you, Ms. Johnson, on this?
I just say keep the bench warrant. We've been trying to work with her. I did advise her to provide me with updates on the new place that she was supposed to be going to because of her child's health concerns, and I haven't received anything, so I have no idea where she's at.
Right, bench warrant is continued. Thank you. All right, one moment. Mr. Stevenson is going to go into a breakout with Ms. Moeller at this time, and we won't have anything else to call until that has happened.
Okay.
So Ms. Moeller, we're waiting on you. All right, the court will recall the matter. I'm sorry. Is anyone here? I know I said we wouldn't have anything, but now I do. The court will recall the matter of the state of Michigan versus Daniel Cox, case number 18S00874. This is actually on the docket today for defendant's motion for destruction of biometric data and arrest records. It was set there because the defendant did file that particular motion. Unfortunately, it appears the defendant may not have received notice for today's hearing. So therefore, we're going to adjourn it out to give time for him to have notice of the hearing today for whatever that may be worth for future reference. I'll schedule it over to April 22nd at 9. I'm gonna make it 10:30 a.m. So we'll set it for 10:30 a.m. on April 22nd. Thank you. Now we'll be in recess until they return. Thanks. All right, the 14B District Court is back in session. The court will call the matter of the State of Michigan versus Kevin Stevenson, case number 23 FB 1039.
Rachel McDuffie for people.
Assistant Public Defender Allison Mueller here on behalf of Kevin Stevenson. Mr. Stevenson, can you state your name for the record, please?
Kevin Deshaun Stevenson.
Thank you, Mr. Stevenson. Mr. Stevenson, I need to arraign you on a violation of your probation. It alleges here that on January 3rd, 2024, you were involved in assaultive behavior and obtained a new criminal offense from Washtenaw County Sheriff's Department report number 24692, in which it alleges that you did assault another inmate. You're right. You have a right to have a hearing on this matter, at which time, if it is found that you did violate the terms of your probation could be revoked. Ms. Mueller, have you had a chance to go over that with your client?
I have, Your Honor.
What would your client like to do?
Your Honor, could I ask a clarifying question? Mr. Stevenson believes that he does have or has served the 93 days that he was originally sentenced to. I'm not sure if he'll be getting full credit for that. If he is, does he need to admit to the violation in order to have him unsuccessfully discharged from probation with credit for the full time served?
I guess that's a good question. He was, so he appeared for sentencing back on August 14th, 2023. At that time, he had 42 days credit already. Ms. McDuffie.
Your Honor, the reason that he's still here is because he originally had wanted to basically complete his time. I think when he was brought in on the more recent felony charge, but then he said that probation had actually been helping him and he wanted to stay on it. And so he actually chose. So this case was adjourned and he was continued on his probation and he's been coming in for reviews while his other cases are pending. So there wasn't, I think the clock stopped on his accrual of credit because he wanted to remain on that probation. And so if he has since changed his mind again, I mean, he has the option to do that, but that is why he had not quite maxed out, is because he had opted to continue his probation while he was in on the other cases.
He was getting some credit though, starting in November, at least. He was, well, he got a bench warrant on November 30th, and then it looks like he was arraigned on December the 8th. So we really do need to know the number of days credit he has, which is what I'm trying to.
I got out February 13th.
You got out on February 13th?
Yes, I was released to treatment, and then the fight happened December 29th. I get arraigned today at 1 o'clock on that case.
All right.
She was right. Like the probation did help. I call my probation officer every week.
No, I know. I'm not saying.
know,
I'm just trying to figure out how much credit you actually have. That's what I need to do at this point.
Okay.
Because you had 42 days before. And even if you want to have your probation reinstated, I need to know whether we can do that or not, based on the number of days of jail credit you're entitled to versus the one you may be asking me to give you. Those are different things. So I want to know what.
My time was up January 1st. I don't remember the last court date we had. I think it was December. I don't remember. I know my time was up January 1st. That's what we originally discussed. And then I thought it was a good idea just to stay on probation because it helped. So I stayed in jail. Either way, I still stayed in jail. I thought I was going to get out on the other charge. I didn't. So I still stayed in jail. My other charges.
PR bond. I gave you a PR bond on December 18th.
Yeah.
Your Honor, I just noted too, and I don't know if this matters. It does look like, I don't know exactly how that works with probation, but on JIS, it says the probation was formally reinstated on the 8th of January. I believe the assault in the jail happened on the 3rd. So I don't know if it was reinstated after the assault, if he would he have still been on probation when the assault in the jail occurred? Well, when the alleged assault happened on the 3rd?
The assault happened in December.
Oh, okay. Sorry. I was going off of JIS on that. I'm sorry.
The assault happened December 29th. That's when I got into the fight.
Okay, well, let me see here, this report. I don't know if you have that right, because the report says it happened on.
It is.
Yep, he's right, December 29th. So yeah, he was reinstated at that time. All right, back to my original question. How much time does the defendant have if he apparently came in on December 8th? Well, that's when he was arraigned. What day did you come in on, Mr. Stevenson? Do you
The
know?
28th of November, or I think it was the 28th.
All right, so he came in on November 28th.
So it looks like on his court date on December 11th, on my report at that time, he had 40 days credit as of January 8th.
Well, that can't be right because he already had 42 days credit when we sentenced him in August.
So 42 days. It was up January 1st. That's when I was done.
So we sentenced him in August. We gave him 42 days credit at that time on a 93-day jail sentence. Did he have an additional 40 days? Is that what you're saying, Ms. Johnson?
Yeah, okay.
I'm just reading through my notes. Sorry, Your Honor.
Okay, thank you. That's okay.
My understanding is that the 40 days that was as of the January 8th was because we had him on the contempt because he had already did his time for the original charge. But I could be mistaken.
Well, the original charge was home invasion and DV. It got dismissed. And then I got sentenced to contempt of court probation after doing the 42 days. I came back. I had 42 credit before I came back November 28th. So from November 28th to January 8th should be the credit time because that's when I was reinstated, January 8th, if I'm hearing it correctly. I don't mind probation. Like I'm still adamant about that. But if I have more stuff still coming, so if this is something I have to continue to do while I'm on probation, I'd rather just get it over with and get it gone.
So I'm looking at X jail November 30th of 23 through February 13th of 24. He's got 76 days. February 28th, that doesn't count. That's when he turned himself into jail for his circuit court matter. And then he's been there most recently on this new arrest since the 22nd.
Can someone calculate between November 28th and no? You say you came back on November 28th?
November 28th until December 13th. I think I got out February 13th. And
all right, you may have gotten out in February, but with us, you get only credit through December the 18th, and that's the number I'm trying to figure out. So November 28th to December 18th is how many days, please?
But I thought it was reinstated on the 8th of January.
No, you were yes, you were reinstated then, but you got a PR bond on December 18th, so we were no longer holding you. You were being held on something else. He says how many days?
What was that other date, Your Honor?
I'm sorry, I'm not sure what you're asking.
Well, you said November 18th until what date?
I said November 28th through December 18th. He got a PR bond with us on December the 18th.
I'm counting 21 days for that.
You have to include both both days, the first one and this. Okay. So that gives him a total of 63 days.
Plus 3 days I've been here.
Oh, But we don't have a warrant for you, sir. You were just a failure
Oh.
so you were just a failure to appear, and I adjourned it because we had a good report prior to then because you were doing so well. So I didn't
Yeah,
issue
I
it.
was on the Zoom. I just didn't have any service. And I called my probation officer immediately. She said, just make sure you bring yourself to court Monday. So I told the people here because it wasn't on the docket yet. I was like, make sure I'm in court today.
Gotcha.
Yeah.
So technically, he has 63 days on the 93-day sentence. So what is your client? He needs to admit to the violation, and then he can decide what he wants to do.
No, I'd rather just reinstate the probation. That's what I originally wanted anyway. I need this.
All right.
Oh, okay. Oh, sorry, Ms. McDuffie, go ahead.
No, I'm just saying,
Our judge.
So since his violation is a new charge, what we normally do is adjourn the violation to find out what happens with the new case. I don't personally have any objection to that happening here. It's a little bit unusual because, like I said, Mr. Stevenson wants to continue. His probation is being served while he's in custody, and I think I don't remember, he's an MRT or I forgot what he's enrolled in, but he's basically completing his requirements where he is. So I don't have any issue adjourning to find out what happens with this new case, given that he's still fulfilling his probation programming where he is now.
I should be getting out today. Is what, because I still have court Wednesday with county.
All right, I'll adjourn them. He's gonna rain on that new one today too. I'll adjourn this one to April 29th, 2024 at 9 a.m. Nope, 10 a.m. And bond is PR. So we'll see you on the 29th, sir.
Okay.
All right.
Thank you. I appreciate you, ladies.
All right. Bye-bye. All right. The court will call the matters of Tolbert Smith. Case numbers 21W001603B, 23W002350A, B, and C, as well as 21W001603A.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Tolbert Smith.
Mr. Smith apparently is still refusing to appear before court. I believe I've already signed the competency review order in this case, so I guess we just need to set it over for a date at which time we can try to have some report from an evaluator at the forensic center. I'll put it out 60 days or so to June 3rd, 2024 at 9 a.m. Any objection or any comments from anybody?
No objection from the township.
No objection, Your Honor. I did try to see him again last night and he's still refusing.
Well, on that note, I guess we're all set. We'll see you on the 3rd on this matter.
Okay.